Hello and welcome. I am Professor Ashmi Raman and this is Module 21 of International Criminal Justice. This module is Modes of Liability Part 2. In this module, I will discuss with you Article 28 of the Rome Statute of the International Criminal Court that deals with superior command responsibility. Superior or command responsibility is a form of liability. It is a form of indirect accountability imposed on the de facto, that is by fact, or de jure, that is by law, superior in crimes committed by or participated in by her subordinates during wartime. This doctrine was established through the Hague Conventions of 1899 and 1907 and has been codified through Article 28 of the Rome Statute of the International Criminal Court. In foregoing modules, we have had occasion to discuss this doctrine. This doctrine is based on the principle that members of the armed forces must be under the control of a superior body or a superior person who is ultimately responsible for their actions. This superior is required to prevent and control violations committed by her subordinates. In other words, a superior would have to have effective command and control over her subordinates in order for her to come under the purview of Article 28 of the Rome Statute. According to this Article 28, a commander will be responsible for failure to act when there is a duty to act. This responsibility arises from the assumption that the superior, by virtue of her being a superior, is aware of the conduct of her subordinates and therefore is aware of the crimes perpetrated by these subordinates. As a consequence of the knowledge that certain acts may constitute crimes, the superior is obliged to prevent or punish such criminal activity. Failure to do so would make her liable for the crime under the doctrine of command responsibility under Article 28. Thus, broadly, this doctrine, that is of command responsibility, attempts to draw a distinction between military and civilian responsibility, imposing a greater duty on military superiors to report crimes in the time of war. Respondeat superior, as it is called in Latin, is codified in Article 28. Article 28 is divided into two parts, command responsibility and civilian responsibility. The difference between the two forms of responsibility are clearly outlined within Article 28 itself, considering the different mens rea of both types. In the ICTR and ICTY statutes, there is not much difference between these two as compared to the ICC statute. To incur a liability, a military commander must know or should have known, whereas a civilian superior must either have known or consciously disregarded the information which clearly indicated the criminal activities that her subordinates were perpetrating or intended to perpetrate. In other words, a superior is one who gives an unlawful order, and that is as much culpable as the subordinates who have been acting upon the sanctions and directions given by the superior. However, the Rome Statute changed the law of command responsibility because of the complications in prosecuting civilian superiors when they fail to conduct proper tests to control their subjects or their subordinates. Article 28 also discusses the recent application of the traditional doctrine of command responsibility. Thus, the evolution of the doctrine of respondeat superior comes from the Latin phrase which means let the master answer, respondeat superior. The phrase suggests that as a high-ranking superior, a person should be held liable for the workings and the actions of all the people under her, largely based upon the common law concept of vicarious liability. Let us now look and try to analyze and interpret the provisions of Article 28. Under Article 28 of the Rome Statute, a commander or a civilian superior would be held responsible for the crimes perpetrated by his or her subordinates with regard to Article 5, that is, the crime of aggression, Article 6, the crime of genocide, Article 7, crimes against humanity, and Article 8, war crimes. Further, under the provision of Article 28, the commander or civilian commander would only be responsible to the extent that it failed to prevent or punish the subordinates' criminal activities. If the commander is criminally responsible for planning, instigating, or ordering the commission or any act of omission that led to such a crime, he or she could be held directly liable under Article 25(3)(a) of the Rome Statute as a co-perpetrator, as we discussed in the foregoing module. However, it is understood that every command responsibility case takes its own merits depending upon the facts and circumstances of each case, and that is why it is not always easy to hold a superior a co-perpetrator, which in fact explains the entire reason for the existence of this doctrine. Now, Article 28 of the statute provides a distinction between a military commander or a civilian who effectively acts as a commander under Article 28. In both of these cases, a superior and subordinate relationship can be proven to exist. Article 28(a) and 28(b) talk about the military superior and the civilian superior. The ICTY, in the landmark decision in the case of Liability, gave the first elucidation of command responsibility by an international judicial body. The Liability bench held that the doctrine of command responsibility includes not only military commanders but also civilians holding positions of authority, and not only persons in de jure but also those in such position de facto. The Liability decision also necessitated the first conviction of an accused person for rape as torture by the International Criminal Tribunal, and Chambers considered that the rape of a person would be a contemptible act which strikes at the very core of human dignity and the physical integrity of individuals. Therefore, the acts of rape included torture under customary international law. In a second case, that is the Kajeli Jelly case before the International Criminal Tribunal for Rwanda, the ICTR held that it would be immaterial whether the relationship between the superior and the subordinate is de jure or de facto, until the extent that the superior had effective control and command over the subordinate, and in fact that is all that matters, and in furtherance of that command had reason to know that the perpetration of crimes were being in fact committed. Under Article 28(a) of the statute, it is with respect to only commanders who are formally appointed as part of a military command function. This provision is applicable to each chain of command function, whether the superior person possesses the highest rank or is a mere team leader. The term command, therefore, is used rather loosely. The term effectively acting as a commander includes a broader line of commanders. It includes those who are not elected by law. However, they perform effective command and control over their military subordinates in lieu of the chain of command. Article 28 Clause B of the Rome Statute includes those superiors responsible for the actions of their subordinates that have not been mentioned in Article 28(a) of the statute. It includes civilians who have effective command and control over their subordinates, and in pursuance to that, those who failed to prevent or to punish the crimes committed by their subordinates. In the Coridich decision, the ICTY stated that great caution has to be taken while assessing whether a civilian would be responsible as a de facto superior. All facts of the case must show that the superior had excess or tremendous influence over the subordinates, and crimes committed by the subordinates were under the effective responsibility and control of the superior. It must have become clear to you now that effective control or effective command is the benchmark and the bedrock of this kind of command responsibility. Article 28 of the statute provides that in case of military commanders, they are required to possess effective command and control over the military troops, whereas in case of civilian superiors, it is required that the commanders show that they are in a position to possess effective command and control. It is now settled jurisprudence before the International Criminal Court, the International Criminal Tribunal for Rwanda, and the International Criminal Tribunal for Yugoslavia that the term effective control refers to a material ability to prevent and repress the commission of crimes by the subordinates and by any other authority that would fall short of the threshold laid down by the jurisprudence of these three tribunals. All the three are structurally different, yet the ICC's command responsibility doctrine mimics most of the provisions given under the statutes of the ICTR and the ICTY, especially where they explain what is the duty of the superior after becoming aware of the subordinate's criminal behavior or criminal intention. This mimicry is seen by the similar use of terminology in all the three provisions of the statutes, that is, the use of the term necessary and reasonable measures. In order to indicate that a superior subordinate relationship exists or may be said to exist in case of civilian commanders, there are certain factors that can be used to establish the existence of such a relationship. They are as follows: 1. The official position of the individual. 2. The power of this individual to give orders. 3. The power to ascertain the compliance with such orders. 4. The power to order forces to take part in hostilities or to compel civilians to take part in hostilities. 5. The power to promote, remove, replace and discipline troops or civilian groups. Therefore, a chain of causality is created. In the Bemba Gombo case, the ICC stated that the term result of in Article 28 of the Rome Statute creates a causality relationship between the effective control of the superior and the acts perpetrated by the subordinates. The court applies the but-for test, which you may have been familiar with from tort law, in order to determine causality, as in, but for the failure of the superior to prevent the crime, the acts committed by the subordinate would not have taken place. It is not a mandatory provision, however, because the prosecutor has to merely show that the superior, having effective control, failed to take all necessary and reasonable steps to prevent the crimes and hence increased the chances of the commission of the crime. In another case before the ICTY called the Hadzi Hasanovich case, there were people who were found to have no effective control over their so-called subordinates. The appeals chamber had found that the alleged senior officers of the army of Bosnia and Herzegovina in fact exercised no effective control over the foreign El Mujahideen forces which were operating in the same place as the Bosnian forces. As a result of this, the court was forced to conclude that the convictions for criminal acts committed by the unit were reversed during that particular period in the year 1993. The trial chamber based its findings on three main grounds. Firstly, that the powers to give orders to El Mujahideen forces detachment did not exist. 2. The conduct of combat operations involving the Al-Mujahideen forces detachment was not there, and 3. There was no presence of any other superior authority over this detachment. Thus, the appeals chamber failed to prove the causality link that we see from the Bemba-Gombo decision, and thus ultimately the chamber relied on the findings of the lower court that even though the Al-Mujahideen forces took part in warfare at that particular time, but the officers of the Bosnian army did not have sufficient control or effective control over them. Thus, although this detachment fought alongside the accused detachment, these forces did not have a significant level of independence, and free will, and so they were not under the effective control of the accused. The main element to determine whether a commander knew is mens rea. The liability of a military commander under Article 28A and B with respect to the mental element of the crime is that she should have known, or given the surrounding circumstances, should have reasonable grounds to know that the acts are being perpetrated or are in the planning stage of perpetration by subordinates. The first standard is always that the superior had known. In its absence, it is upon the prosecution to show through the evidence provided that the superior should have known the crimes committed by the subordinates. Courts have isolated a few elements that would be required to show in order to assume that the superior had reason to know that the crimes perpetrated by the subordinates followed the chain of responsibility given by the superior. Let us look at a few evidentiary factors that are required to be produced in order to establish this link. 1. The number of illegal acts. 2. The scope of these illegal acts. 3. The number of forces involved. 4. The means available for communication between the subordinates and the superior. 5. The scope and nature of the superior's responsibility towards the subordinates in the command structure. 6. The location of the superior and the geographical or spatial location of the crimes committed or said to have been committed by the subordinates. In the case of civilian superiors under Article 28B, it is required for the prosecution to show that the superior knew or consciously disregarded the information which indicated the commission of the crime by the subordinates. The standard maintained for civilian superiors is more challenging than that of military superiors because it mentions that the superior must consciously disregard the information. The standard laid down is therefore subjective because what is conscious? Article 28B clearly shows that the civilian superior must act recklessly while disregarding the information that has been brought to their attention. Let us now discuss the duties of the superior. Clearly, the duties of the superior are indicated in omission and in commission. Article 28 of the statute of the ICC tell us that the main duties of the superior are to protect, to prevent the crime, to repress, to rebuild, and to submit the matter to competent authorities for investigation and prosecution in case of the commission of a crime. Each of the duties mentioned here may constitute a separate criminal charge under Article 28 of the Rome Statute. A plain reading of the article would show us that ultimately the superior will be held responsible for what is known as the principal crime, although it is not as clear cut as it might be on a first reading. The identification of what would constitute as necessary and reasonable steps in order to prevent or punish the crimes would indirectly depend on the degree of the effective control that a commander or a civilian commander is able to exercise in ordinary course towards his subordinates. The responsibility of the superior is therefore a mode of liability which might be useful where it is difficult to prove that the master had an important or active role to play in the commission of the crime. However, it can be made out that they did have an indirect role to play because they enabled the commission or created such an environment which could have prevented the crime, but due to their omission or willful blindness or reckless disregard, they made this impossible. In conclusion, superior responsibility at the international level is a hierarchical standard that holds higher level military and civilian officials responsible for the conduct of the officers and the lower ranking staff that they are responsible for or in charge of. It does not have any parallels with the basic or general principles of liability in most national jurisdictions. In national jurisdictions, in fact, the closest that this can come to is the doctrine of duress. The effective control, omission, duties and functioning of the superior covers many situations when a commander fails to take action or take such actions which worsen the wartime damage. Article 28 of the statute gives us all the various elements of command responsibility that must either be proven by prosecution to hold someone criminally liable, or it should be shown that the superior subordinate relationship existed and measures to prevent or punish perpetrators were not taken, and the application of the doctrine of superior responsibility, as well as the difference between command responsibility of military and civilian commanders, are all outlined in Article 28. It is important while finishing our study of this mode of liability to understand the pyramidal nature of responsibility under international criminal law. International criminal law is not able to hold each individual that commits an actual crime responsible for their offences. This is completely different from municipal law. International criminal law works in the nature of a pyramid. At the top of the pyramid is the person giving the orders, or the person who, having knowledge of the acts being perpetrated by those below, fails to prevent the act. And therefore, the doctrine of command responsibility operates throughout the structure of international criminal law and cannot be disregarded as an important mode of liability. Thank you.